All right, it being 8:31 now, we're gonna open this work session on HB 107. Um, for the record, this is my first time seeing a subcommittee meeting, let alone attending one or being a chair of one. So bear with me as we go through this here. I understand it's relatively informal. Obviously, we want people speaking one at a time, but um, I guess the first order would be to have the sponsor of the bill maybe discuss. We've heard your testimony already, so if you have anything new to add, or you want to emphasize some things, and then maybe take some questions, and we could discuss your proposal.
Thank you, Mr. Chairman. Members of the subcommittee, I appreciate the opportunity to be here, and I'm here to work with you, answer any questions, engage in any discussion that we may want to have. I'm going to lead with my chin and say we don't want to let the perfect be the enemy of the good. The fact of the matter is, it's my opinion that we have a loophole in existing RSA, and two cases have been brought forth, unfortunately, both from the town that I live in. And a constituent has asked me to file legislation to close this loophole. And while I appreciate the need to keep opportunities open for people that are on the registered sex offender list, it's my opinion that they should not be employing, be managing, or be the direct supervisor or left alone to work one-on-one with minor children. That puts both parties, both the registered sex offender and the minor child, in potential jeopardy. And so it's in our best interest to protect both of those groups. I know there was a lot of questions around, primarily with minors part of the bill as written. And I, I don't think I was very clear on what the intent there was. And so I'd like to clarify what the intent is there. So maybe we can find some language that we can all agree on to clean that up. So when we see that language, what the sponsor of the bill, myself, and what the constituent is asking for, this goes to things like schools, daycares, after school programs that you might have, right, where kids go after school, boys and girls clubs, things like that. It's not meant or intended to prohibit somebody working as a clerk at the corner store. That's not, yeah, technically, are you providing a service to minors? Yeah, you're selling them whatever they're coming in to buy, bread, milk, candy, whatever it is. But the customer is not an employee, right? So it's this employer employee relationship link, this possibility that the employer, the manager, the supervisor are working directly with children that are registered sex offenders. That's the link we want to break. That's the firewall that we want to reinforce. So, can somebody work at a local grocery store, as a bagger or whatever? Yeah, absolutely, because it's a customer, right? In those discussions we were having, it was a customer coming in. Now you can say, well, an after school program, the kid is the customer because the parents are paying to send the kid. And that is right, right? But the job there is actually supervising children, right? They show up after school, and if you're working there, you're supervising, you're managing, you're around those children, and that's the link that we're trying to break. That's the intent of the law. I'm certainly hoping that we can come to some mutual language that will reinforce that firewall. The challenge that I have is most of the proposed amendments that have been brought forth by others, in my reading of those, it simply adds language but is ineffectual at building the firewall that we're looking to build. That the language ends up being so loose to make it easier for registered sex offenders to find employment that it doesn't close the loophole. And if we're just going to change language, but the loophole remains open, then really we're wasting our time. We're spinning our wheels in the mud. The idea is to put this firewall up to close this loophole. I'll take any questions anybody may have.
Representative Muse?
I just want to say that this particular crime is just about the worst thing you can do to a person next to murder, because the child who's the victim is never really the same again. That person is effectively gone. But I did think that in his note, Representative Lynn made a good point, in that one of the things that we have to balance is the need to minimize the risk to children with the fact that we can't create something that's so overbroad that it would totally prohibit many types of employment for people who may be trying to rehabilitate. So one thing I would suggest is to, and I know this may sound a little strange in the context of this hearing, but to take an approach that, kind of from the Gun Violence Prevention Handbook, which essentially is, we know that nothing that we can do in statute will totally eliminate or prevent these things from happening. But there are things that we can do to minimize the risk. So an approach that we could take is, are there some things that we can do to the statute that will further reduce the risk of this happening to children? And my concern with your need to almost totally close the window is I don't think that we can do that, or it would be constitutional necessarily for us to do that. But looking at the statutes of other states, it does look like there are some things that other states are doing that perhaps we could adopt here in New Hampshire too. So the idea, while it would be wonderful to close the window completely so that these incidents never happen again, as you say, if we don't throw out the good in search of the perfect, what we can do is close that window to a point where it's harder for these types of offenses to happen than perhaps it is now, and that's the approach I'd kind of like to see us take.
Thank you, Representative. If I could respond, if that's okay, and then I'll take any question you have. Thank you, Representative. I appreciate your remarks, and I don't, on the face of it, I don't disagree with any of it, for sure. I think we have a lot of common ground. The one thing I have to say is I can't comment on what the representative submitted to the committee or the subcommittee, as I wasn't put on copy on any of that. So I don't have those materials. So the representative you spoke to, I've never received copies of those, so I can't really speak to what those proposals are, other than things that I saw last session.
You had,
Yeah,
Yeah.
no, if I didn't say, it is exactly what I submitted last session, but I'm sorry if I didn't copy it. But that's, that's exactly, as you can see, it even has the date from last time. So that's the same thing that I offered in the last session.
Thank you, Representative. I appreciate it.
if I may, and this is where I had a hang up with, and this is how I interpret this. And I understand your intent. However, down the road, when this becomes law, that intent is going to be interpreted by a judge, and they may interpret it differently. The first part is employment in business providing direct services to minor or direct supervision to oversight of minors. If you put the emphasis on employment and leave business out of it, it makes more sense as to what your intent is. But if I was to put the emphasis on business, that's where people are thinking that any business that provides a direct service to minors you couldn't work at, which would mean McDonald's or a movie theater or a convenience store. And I understand that's not your intent. But if I put the emphasis on business, that's how I interpret that, is that any business. So we would be limiting work virtually anywhere. So I think that's the hang up.
Yeah. So if striking a word gets you to where you need to be, namely, taking the reference of business out and making it an employment only. So, well, let me just back up a little bit. I'm not good at thinking on my feet, so bear with me. The burden should be, in my opinion, on the employee. The burden should be on the registered sex offender. They're the ones that, have committed a crime, tried by a jury of their peers, found to be guilty, and are taking the punishment that society doles out for that. The burden, I believe, should be on that person. They're the ones that need to take responsibility and full responsibility for the consequences of their previous actions. And I agree. So there was actually other language in the original bill that was stripped out during a working session that we had last year. So we had an extensive working session last year. I think Representative Manous, were you part of that last year or no? Yeah, so we had state police, we had attorney general, we had Department of Justice. Maybe that's part of attorney general. We had victims' right advocates, ACLU, and registered sex offender advocates, and we all sort of agreed on the language, and that was the language that's put in front of you. I'm not opposed to further changing. The other thing that I'll bring up is during that work committee. I'm not the guy that stripped out the list of examples. It was actually the groups that came before us that recommended stripping out that language so that it doesn't become too narrow by way of examples. So personally, I think it's a cleaner RSA without the list of examples. But I mean, if that's what it takes to get over the hurdle to leave that language in, I would suppose that I'm fine with that. But that language was stripped out at the request of others that came to the working session the previous year.
Yeah, I think a lot of what I was going to say has already been kind of brought up in this situation. I think, in the beginning, when we heard this in the first place, it was the language was too broad, and then how is this going to be interpreted? And then also, I think, who is the onus going to be on? Is it going to be on the employer and the employee, or the employee? And then how is that defined? But so is this proposed amendment actually is this what you're trying to use now, or is this just for reference of what was submitted last year?
Thank you, Representative, for the question. I appreciate it. This is not my amendment. So I brought the bill forward again this year, and what I brought forward this year is what had been agreed to and approved out of committee, out of a work group and out of the committee last year. This was a floor amendment that was brought forth to House session last year when we were meeting in Manchester, in the function room in Manchester. So the person that I think can speak best to this proposed change would be the representative behind me to my right, because it's his amendment.
Sounds good. I'll wait. Thank you.
And this floor amendment was voted down for what it's worth last year during session.
Okay. I think just as far as what the DOJ was saying, clarifying this and saying that that provides services exclusively or predominantly to minors really clarifies the language a bit. So I know it was voted down last year. So
well, I like that. So it's not parts, right? When you're voting on the floor, you can't say, well, I like paragraph 1, but I don't like paragraph 3.
Okay.
I don't disagree. I like that language too. And it's, the list, I don't care. The advice was to get rid of the list to make it less confusing. If we want to put the list back in, because that's what's in current RSA, that's fine too. So yeah, I think I agree with where your stance is at.
Okay. Thank you.
Thank you.
Representative Bolden.
On the topic of the list, I think that I understand that the sponsor wants to be flexible and kind of work with the concerns of the committee. But I think that initially, like in the initial hearing, the sponsor's testimony and other testimony kind of helped me understand that the list was the problem. And lists in legislation can be problems because when that day comes that someone's in front of a judge, the judge says, well, what did the legislature intend? And they'll take into consideration everything that was discussed in committee, depending on the available notes, which depends on the clerk. And historically, that's going to be like a one to 2 sentence summary for every 5-minute speech. every 5-minute bit of testimony. So that's a challenge for a judge to determine. And so they're going to lean to some extent, I imagine, and I'm not going to speak too heavily to what judges think, but I think that they would lean to some extent on just simply the way that the law is written. And I do think that the way that it's written currently doesn't take into consideration employer situations and supervisory and employee situations. And that's I'm a little I don't know if like we've kind of like lost the thread in having a subcommittee and all of the different stakeholders on the bill and all the feedback and the amendment proposals, but that seems like that's the issue that the sponsor brought up with the news articles that he gave us. The person who was employing a teenager in his landscaping business was pretty clearly not violating the law as it was written. And I don't know how I guess the bit about provide services predominantly to minors would cover the carnival situation. But I have a 16-year-old. She worked at Market Basket since, the grocery store we won't name that's a pillar of this community, and is where you can save money. But she worked there since she was 14. She applied the day that she turned 14 because that's the earliest she could possibly work under the law. And she really enjoyed it, but without a doubt, she spent a whole lot of time with adults whose backgrounds we're not familiar with. And I do think that it's a valid concern. And Brad gave us this handout, and it looks like crimes against minors, sex crimes against minors, are included in all 3 tiers. So that I think had been wondering during the hearing whether the RSA should speak to the type of crime, but it seems that that's not really necessary because if you're on the registry, that doesn't mean that you've committed a crime against a minor, but you've committed a crime that was grouped in severity with a crime against a minor of varying degrees. But I was going to propose, since laptops in subcommittee are, I think, okay, and Googling in subcommittee, I think, is okay. I would like to look at, because didn't the landscaper thing go to court and that's why it made the news? I
Yeah.
would like to look at what the discussion was in the courtroom and see if there's anything we can glean from that as far as the functionality of the current law. I don't know if that would be helpful or if I'm pushing us off the rails on my own, but I just want to give my input on that I really think that what the sponsor wants to do makes sense. I think it's achievable. I think the list is counterproductive, but whether or not the list is counterproductive might be highlighted by anything that a judge may have written about the landscaping guy. So I'm going to Google that now. That's
Mr.
okay.
Chairman, if I may.
Yes.
Thank you, Representative. One, for being almost as verbose as I tend to get, because it gave me time to read this amendment and refresh my memory as to why I was against it. And I'm still against this amendment as written. This does not close the loophole. When you read paragraph 1, this is going exclusively to people working with children in such areas that I listed, schools, after school, that sort of stuff. But it leaves the possibility of a registered sex offender hiring a minor child. It leaves open the possibility that a registered sex offender is the direct supervisor of a minor child. It leaves wide open the possibility for a registered sex offender to be in a position to work one-on-one with a child. Those 3 things, that's the loophole. That's what the landscaper case was all about. That's what the carnival ride operator case was all about, is you have registered sex offenders that are in direct supervision, direct management, or employing minor children. That's the loophole. That's the part that we have to close. This, with all due respect to the representative, does not close that loophole. And that's why I fought against this floor amendment on the floor, and I believe that's why this floor amendment was rejected by the body. Now I can't say why people voted certain ways, but this does not close that loophole. And so while I don't disagree, there probably needs to be some wordsmithing around direct supervision language that's early in. That's the part we want to close. I don't think registered sex offenders should be able to hire minors. That puts the registered sex offender in a position of power over a minor who's already a minor and doesn't have the knowledge that we have. If you're a direct manager, a direct supervisor of a minor, and you're a registered sex offender, that puts you in a position of power over a minor. That shouldn't be allowed. If you're a registered sex offender, you shouldn't be, in my opinion, we shouldn't allow that registered sex offenders work one-on-one with children without at least one other person there to make sure the conversation, the activities don't go sideways. That's the loophole we're trying to close.
Well, perhaps at this point, we can have Representative Lynn speak to his proposed amendment and his opposition to it.
Thank you, Mr. Chairman.
Thank you.
Thanks very much. So I guess, I think if you were to ask Representative Verbil and myself, and I suspect all of you, what do we want, if we were to give us all an example of, 10 or 20 sort of situations and say, where do you all come down? I suspect we would all come down in the same place. We'd all say, yep, in this case, the person shouldn't be able to have this employment, or this case, the person should. The problem I have with the proposal that has been offered and that is now before the committee is if you say that a sex offender can't have, and let's take out the business for a minute. Even if you say cannot have employment that provides direct services to minors. Now, Representative Verbil said, well, we don't intend to prevent somebody from working in the convenience store, but the courts are not going to be. They're going to be concerned with what the law says, and if it says it pretty clearly, it's not. It's a very well established principle if the law says something very clearly, you can't kind of go behind that. So the law says you can't provide direct services to minors. So you get hired to be the checkout person at Market Basket. And through the checkout line comes the minor. Aren't you providing direct services to that minor? Of course you are. You're providing direct services to the minor. And so that means that the person, a registered sex offender can't get a job at Market Basket working as the checkout person. Now, maybe you want to do that. Maybe you want to say that, although, and by the same token, couldn't be the person behind the counter at 7-Eleven or Cumberland Farms or whatever, because again, a minor may be the one that comes in to buy, a pack of gum. And you're providing direct services if you're so I guess my only concern here is I'm no fan of sex offenders, believe me, but if there are almost all of them are not serving life sentences. They're going to be released from incarceration at some point. And then the question really is, do you want them to be able to get a job in any place where it's sort of relative, they're reasonably likely to be able to get a job? I mean, they're not likely to be getting a job as an executive at BAE Systems or something like that. You're talking about these kind of, relatively, for lack of a better term, menial jobs that are most likely the ones that they can get. And if you have a statute that prevents them from even doing that, you've essentially guaranteed they're going to be on welfare, and we're all going to pay for it. And, and I don't think we want to do that. So I think that the way the statute exists right now, which contains this list of list of things that are explicitly prohibited. I agree with Representative Verbil that you don't want that list to be the exclusive, because I completely agree with that. but I think that it does serve the purpose of kind of capturing what generally the kinds of things that are just flatly prohibited. What we want to say, look, you can't work in these industries, so to speak, that are, that are sort of directed at children. And then what the example, I mean, what I had proposed in the bill that was offered in the amendment that I offered last year was the sort of catch-all at the end, which is more broadly worded, but that says, or any employment or volunteer activity that provides services exclusively or predominantly to minors. Now, I'm the first to admit, is that, absolutely crystal clear so that you will be able to tell every single case whether it fits squarely within that or not? No. I'm not sure you would ever be able to have language that would do that. But it seems to me what it does do is it says that if, let me draw this distinction. I would say this would not prohibit a person from working as the counter person, the checkout person at Market Basket, or the counter, the behind the counter thing at 7-Eleven or Cumberland Farms, and also wouldn't prevent someone from, for example, getting a job at a restaurant as a waiter, where the clientele of the restaurant is sort of the general public. Is it possible, that there will be a minor that comes into the restaurant sometime? Sure. But I would say that, and this would not capture that. This would not capture the situation of a minor who is providing services to, who waits on the table where there's a minor there. It wouldn't, that employment would be allowed under my proposal. I would draw this distinction. Suppose instead of it being just a regular restaurant, suppose it's something like, and I'm trying to think of a good Chuck E. Cheese. I think that was the one. It's something that it's a kids restaurant where where most of the people that go there are kids. It's not sort of generally. I would say then that is an activity that provides services exclusively or predominantly to minors, and so you can't work there. And I don't. Is there? Under mine, is there a possibility, for example, Representative Verville pointed out, and I guess I think he's probably right. I'd have to concede this. If you get a job at Market Basket, you're a convicted sex offender, will there be minors that are also working at Market Basket? Well, yes, that's true. And so, I think he would call that a loophole. I guess I would tend to, is it a loophole? I guess what I would tend to say is, if that's a loophole and you want to prohibit that, then effectively you are largely saying that sex offenders can't work in the kind of jobs where they're likely to be able to get a job. And I guess the other thing I would say is it likely in that circumstance where you have a registered sex offender works as the checkout person at Market Basket, and there are other minors that also work at Market Basket. Is it likely in those circumstances that the minor is going to be left alone with the other person that works as a checkout person? Probably not. It would seem to me it would be a relatively unusual situation, but I would concede it could happen. So I think what you have to do in the end is balance how restrictive do you want to be? Do you want to give people, registered sex offenders, any opportunity to be able to work in the economy? That's really the decision you have to make.
If I could, so I'm looking at your proposed amendment. Now I'm for the list being in there. I know in my experience as a law enforcement officer, the list is good because it gives some guidance as to what types of things we're looking for. And there'll be no question that specifically that list, there's no question about whether they should be working there or not. adding the part about, or any employment, voluntary activity that provides services exclusively or predominantly to minors covers, I think, everything else, like you said. I think the concern from Representative Verville is the supervision of minors. So aside from it just being working in a place that predominantly serves minors, like Chuck E. Cheese or something, if they're working at Market Basket and that person is a direct supervisor of 2 or 3 minors, or a landscaping company, if there was some language in addition to services exclusively or predominantly to minors, or in employment with direct supervision of minors.
Or sure, no, that's a good point. I think that's. I mean, maybe you could add on to the end of it, or any employment or voluntary activity that provides services exclusively or predominantly to minors, comma, or that or in which the sex offender would be the direct supervisor of a minor.
Yes.
If it's okay with Representative Lynn, can I join in? Because I'd like to
Yes.
make an offer to see.
Sure,
Because
sure.
I think we're getting there. I think
Yeah,
we're getting
yeah.
there really fast.
Can I just say this, so we can narrow this down in thinking about time here? The section where you have a definition under public-private employer organization, as far as a background check, I don't disagree that just citing the section rather than redefining it again. So perhaps we can just leave that as it is. It already defines it once in the above section. So in section B,
Yeah.
you're defining it again. So rather than do that, I see in Representative Lynn's proposal, it says,
I
as
just
specified in paragraph 1.
right. I just referred
Just to
back.
clean that up, so we don't have 2 different definitions or 2 different things to look at it. And we don't even have to address that part of your proposal, because it just specifies whatever we come to as an agreement on the first part of it that we're discussing now. You understand what I'm saying?
Yes.
Yeah.
I think that makes some sense.
Right,
Yes.
Thank you for letting me interrupt. 2B feels like it's got to be a no-go. I know that it sounds great, but practically requiring every organization of whatever kind in the state to start doing background checks, it seems like an undue burden, and it doesn't, and it confuses the issue, because I think the intent of the original law is to put the onus on the offender to dictate their own employment, and that when the offender fails to obtain employment that complies with the expectations set upon them, then they suffer the consequences. I think that this committee really needs to have an amendment that eliminates 2B. I don't think we can move forward with that requirement just because of the widespread effects that would have on the state. But as for the landscaper, I read the, well, I'm going to say I browsed the Supreme Court decision, which I believe has Representative Lynn's name on it. And it looks like, and I don't know how much of this has already been covered because I've been multitasking, but the conviction that he got for employing a minor was overturned by the Supreme Court, and they said in their decision that more or less that the list was the problem, and they said we are not persuaded by the state's statutory interpretation, so the prosecutor's interpretation of this law, in part because it requires that we not give meaning to all the words of the statute, but that we instead focus solely upon the phrase the care, instruction, or guidance of minor children in isolation. We acknowledge the state's point that its reading of the statute arguably advances the goal of the statute to prevent child exploitation and abuse to a greater extent than our construction. And then I don't know how to read decisions, but it says it frustrates rather than effectuates legislative intent simplistically to assume that whatever furthers the state's primary objective must be the law. If the legislature disagrees with our statutory interpretation, it is free to amend the RSA as it sees fit. So maybe
I think we're doing that now.
maybe Representative
Mr.
Lynn.
Chair, I have a point of order. I'm curious, I walked in before 9 o'clock. I assume we're doing some kind of meeting on House Bill 107.
It's a
Is that
subcommittee
correct?
meeting.
No, this, I'm sorry.
Mr. Chairman?
I'm sorry if I just wanted to say what I believe that the Supreme Court was trying to say, and Representative Lynn could tell me if I'm wrong, but it seems like the Supreme Court was saying that just because we think that the legislature intended, or like that the goal of the legislature would be to prevent exploitation that results from people meeting through a workplace or volunteer situation, that doesn't mean that the law actually says that. And so it does seem like the Supreme Court wanted to eliminate the list and wanted the legislature to work on the wording.
And I would think they would want it to keep the list and just expand on it.
Yeah, I don't think there was any. I think what the court was saying there was that the circumstances in that case were not sort of clearly covered by the statute, and that, you know, it is, as I tried to mention before, it really is a sort of principle of judicial construction of statutes, that if the statute doesn't cover something, even though if it did cover it, it would further the goal of the statute. It's not the job of the judiciary to say, oh, well, that's great. We're going to interpret the statute as if it did, because that would further the goal. The court won't do that.
Mr. Chairman, if I may.
If I could just hold on, you're from the sex offender registry, is that correct?
I am.
Do you have any? I just want to clear this up because we have literally 20 minutes left here and we'd have to do another work session, which is fine if we need to do that. But do you have any comments on that section? Would that put an undue burden on, first of all, your position and businesses where virtually every business would have to do a background check? Okay.
Mr. Chairman, if it would be possible for me to have 1 or 2 minutes before
Sure.
we yield, because I made some cheat notes. I'm looking at Representative Lynn's cheat notes, and our cheat notes are getting remarkably similar. So I think we might be closer than we think, at least on who's defined by the law. And so I guess if we're going to use Representative Lynn's amendment as the framework, which is fine, then what I would ask is that we add language that language to the effect that a registered sex offender cannot be the employer. So that boxes out the landscaper case, right? So if you're the business owner, you cannot, and you're a registered sex offender, you cannot employ minors because that puts you in that power. Employer, manager, supervisor, or work one-on-one with a minor, right? Those are really the 4 things that I think we're trying to block out. And as I look at he's got direct supervision, right? So we're very, very close. I would say we just want to bar registered sex offenders from being the employer, being the manager, being the supervisor, or working in a one-on-one setting. So if it's 3 people on a landscaping crew, one's a minor, one's a registered sex offender, and one is not, if the one that's not leaves, then the registered sex offender has to go with them, that you can't leave the 2 alone. I think if we added that
Well,
into
the minor could
this,
go with them.
of a minor, I think if we added that into this, I think we'd be in a happy place that we could all agree on with some other tweaks. So with that, I'll yield. Thank you, Mr. Chairman.
One additional thing, and I was actually going to raise the issue of businesses as well. There's also the possibility that an offender can actually own their own business that primarily serves children.
That's why I say employer.
Which I'm not sure the statute addresses or the amendment addresses at this point. So, for instance, they could buy an ice cream truck. They could buy a Chuck E. Cheese franchise. They could. So, if we narrowly focus on just employment, I guess my question for Representative Lynn is, does that preclude would we be precluding people from buying an ice cream truck?
No, in fact, you know what? I mean, that's a very good. I guess I would direct you. I tried to capture that in. So if you read six Roman numeral 1, 6, the first one, prohibition on employment of volunteer services. What it says is, I tried to capture that in there. So a person is guilty of a Class A felony if, having been convicted in this or any other jurisdiction of the various offenses. It goes on to say he or she knowingly engages in employment or volunteer service, then the crucial language, either as the employer
Yes.
or provider of such services, or as an employee or volunteer. So I tried to, that language is different than the current law, because in other words, it's designed to capture just what you said. So you can't be the employer or the employee. That's what that's designed to capture.
Just a quick follow-up. I've been working on another bill that would ban the use of prone restraint in New Hampshire, and under the current, one of the issues that we're having is the current statute actually does ban prone restraint, but it doesn't ban it by name, and it doesn't define it. So it's unclear to people who are actually providing services to children that that's not necessarily something that they should be doing. So my question is do we need to be more explicit than that? Is it to avoid misinterpretation, or is that something that you think the legislature should be concerned with?
I don't know. I guess I think that, where it says that you can't do these things either as an employer or as an employee or a volunteer, I think that's, that is pretty clear. So, as Representative Verville was saying, I think maybe we are in agreement on this. What if you added to in my version, what if you added, instead of ending the sentence, it says, or any employment or volunteer service or volunteer activity that provides services exclusively or predominantly to minors. What if you then put a comma, so that provides services exclusively or predominantly to minors, comma, that involves the direct supervision of minors, comma, or that involves one-on-one work with minors, period. I think that kind of covers, all of the things that we were, that Representative Verville was concerned about, and that, that as sort of a loophole, I think that sort of covers it.
So I think I know that Representative Lynn and I would love to work together to come up with a new amendment. Perhaps we could recess this work committee, give us a week or two to hammer out some details and bring something forth to the committee. If there are members of the committee that have other concerns about other provisions of what Representative Lynn has brought forth, I'm certainly willing to address those too. My main concern would be addressed by this, and so I would yield to the committee members if there's other parts of the bill that are causing concern or pause. We could certainly address that as well.
Representative Prue?
So on the part about getting background checks, those are getting tougher and tougher to get because everybody wants them, and that system is just overloaded. So they might be waiting weeks, if not months, to get a background check to hire somebody. So
Right, and that was discussed, and I think we're gonna hear from the representative
All right.
on that part of it. This is specifically talking about the part defining the statute and the language and the list and whatnot, and I think you guys are pretty close to coming up with something that you both agree on. So that's probably the best course of action, is to let them work on that. We can come back when there's an amendment to it. However, the other part there with Section B, I would like to hear some more information on that and what the burden with that would be on not only employers, but on your department as well. You had a question at some point or testimony? I'll have you in a second here. I just wanted to make sure that you wanted to speak. So I guess the other issue here is 2B, and I had similar concerns with that. If this is interpreted as McDonald's and Market Basket and any fast food restaurant or a restaurant at all, or a movie theater, are all now required to have background checks on everybody, what kind of a burden would that put on you? as a
So
state.
in talking with criminal records yesterday, it would put a burden on, there's a $25 fee assigned to those as what, so some of the concern is who absorbs that $25 fee? If you have multiple applicants applying for a job, when you've got, 10 people applying for 2 jobs, they all need those background checks. Does that cost get absorbed by the individual applying or by the company? So those, they do take time as well, so that would be an issue. And again, we're not in opposition or in favor of the law, but if we're solely talking about criminal background checks, then I won't mention any of the other talking points that I kind of put together here. But I do have to mention one thing that I continue to hear over and over is sex offender, the verbiage sex offender versus an offender against children. We have a number of sex offenders in the state that have not committed any crimes against children. They're crimes against adults. So they don't fit into any of paragraph 1, essentially, that says felonious physical assault on a minor or any assault or child sexual abuse images. They don't fit into those if we're specifically talking about a minor. Those also don't capture one of the laws that a tremendous amount of our offenders fall under, and that's would be use of certain computer services prohibited, which are the offenders that actually are online being caught by police departments they're trying to lure minors to meet them and to have sex with them. So that doesn't fit into any one of those 3 sections above. So if they're convicted of those things, what happens? So I'm not saying that this should be the verbiage, but perhaps any conviction requiring the offender to register as an offender against children may be broader and less ambiguous to us. Law enforcement, I think, in some of these instances, relative to what has been proposed, we're going to have our hands tied. And the way I see things is it is open to interpretation, but depending how that's perceived by the individual officer or the department or the person making that claim, I think that's going to put a burden on those law enforcement agencies to make that arrest or to bring those charges forward.
Thank you.
I also have one of the paralegals from the office who, so one of the big things, and we're talking about paragraph B here on the bottom, how do employers, and I think I brought this up last time, how do employers interpret the criminal background check? So if you are applying for a job at McDonald's, or let's just say, I don't want to use a chain restaurant, but let's say a big chain restaurant, and you've got a conviction in Tennessee, but now you're a resident in New Hampshire. You apply for a background check here, it's going to show you a New Hampshire background check. It's not necessarily going to pull, and it won't pull that Tennessee background. So you might have a conviction in Tennessee that's not going to show up in New Hampshire. So are the restaurants now, are they going to go by are they going to get on to the offender website and see, this subject is a sex offender? Perhaps he's going to do the employer's going to do that. They're going to look at the list. They're still not, for the most part, going to be able to interpret that law, that RSA or that law that subject or that prospective employee was convicted of. Does that make sense to everybody?
It does. Could you explain how it's done currently under current law for the obviously these positions that are on this list here, Girl Scout, school, daycare? Do they get a copy of the background check and interpret it?
So as far as if somebody's applying to like a daycare,
Yes.
I don't know that they do at this point. quite honestly, I don't know. I don't know how many employers in the state actually do criminal background checks. I can't speak for that.
So this is basically the current law is prohibiting the sex offender from applying for these jobs, not making these places get background checks.
Correct. That's the way I read it.
Sorry, I just want to ask a quick question. I know I work as a homeless advocate, so I certainly need a criminal a criminal background check or whatever. What they do is it's called CORI, C-O-R-I, and I was under the impression that that would be nationwide. You would have all of the information, not just in where I work is in Massachusetts, not just in Massachusetts, but any criminal background check. Is that not the case?
What is it called? C-O-R?
C-O-R-I.
C-O-R-I? I'm not familiar with that term. And that's the other thing too, is in this paragraph B, shall conduct a criminal background check. So, and I think I brought this up last time, that means a lot of different things to a lot of different people. Perhaps a criminal record check from, the state of New Hampshire, or somebody that's going to be an actual criminal background check. But again, if you're convicted in Tennessee and we do a criminal background check on you in New Hampshire, that's not going to flag. If you live in New Hampshire, we're going to see your New Hampshire criminal record.
Isn't there two levels, the state and the federal?
Yes,
So we should be doing the federal
again,
as
It
well.
doesn't
right?
say that,
I
but-
know that. That's why I'm asking.
Yes.
Put that in. So to capture everything, you need the second level, the federal check as
I would
well.
say so. And then I think to take it a step further, and again, I want to be clear, we're not in opposition. We're just giving you thinking points because we're on law enforcement side are going to be the ones dealing with the aftermath of this. I think to take it a step further, those who is going to interpret those offenses? So, for example, you might have an assault and battery charge out of, let's say, Massachusetts. You live in New Hampshire, they find that assault and battery charge. That might actually be a sex crime, but it's not listed that way. It's assault and battery. So the employer, how is the employer now determining that? They're not going to have access to that police report. They're not going to have access to be able to say, oh yeah, look, in 1997, he struck his stepson for, while attempting to do this. They don't have access to that. They're not going to be able to interpret that, in my opinion.
Okay. Rep. Verville, if you have a.
What's in front of you does not make any changes, to the best of my knowledge. I haven't compared Rep. Lynn's amendment to my bill. My bill doesn't change the background checks from what's currently in New Hampshire statute, and apparently is working quite well for us. So while I appreciate the remarks of the current speaker, and I've indicated I would be more than happy to work with them for a bill for next term to maybe address some of those concerns they have, what's in front of you does not change the criminal background checks that are currently in place for these things. As far as I know, there's been no problems associated with that. So I really wouldn't want to get this bill bogged down into that, which is sort of a different topic.
I think that was a concern. That's current language. I think is it exactly because it's bold. So there's some changes in there as far as the definition of who.
I don't have the present statute right in front of me now, but I think that the only change that I made in subsection 2B was simply, to instead of listing, as I think the current law does, sort of listing again the stuff that's in one, I just made a reference.
Referencing one, yeah.
reference to
But I know there are background checks done now. I've done fingerprints for school employees, so they do them, and I don't know who interprets those, but it's been done. But nothing's changed as far as that part of it with current law.
Right, we're not changing that in
Okay.
in this bill. The
All right.
current law for background checks remains exactly the same. This
Thank
is
you.
just a closed loop.
Thank you.
Thank you.
Okay, we literally have maybe 4 minutes left here, but
Thank you.
did you have some comments or something you want to quickly speak on the bill? And you can just let us know who you are and what you want to speak about. You can put the microphone on.
Good morning. I'm Abby Simon. I work for Department of Corrections. I am Administrator of Behavioral Health and Sex Offender Treatment Program. So I just wanted to clarify when looking over this, making sure and second what you're saying, because there are a lot of, oh, I think,
Just pull the mic. You can pull the microphone towards you.
can you hear me? Okay, okay. What I was saying is, I just want to second making sure when we're looking at this, for people who have a sex offense, not everyone has a minor that has the sex offense. So limiting people who do not have an offense against a minor does not help them find employment as well. Also, we spoke in one of the hearings previously about making sure that there's structure and routine for people so that they're not reoffending or coming back to the prison for other reasons. So just putting those points out.
Do you know if the current law includes or any sexual assault? You have it there.
Categories that the law applies to. In other words, as I read it, as I read this, and I think this is exactly the same as current law, it applies to any felonious offense involving child sexual abuse, so that child sexual abuse, or a felonious physical assault of a minor, or any sexual assault. So the sexual assault doesn't have to be against a minor; it could be any sexual assault. And I think I assume the legislature, when they originally passed that, was the theory was there. I think there's some evidence that sexual assault, whether it's committed against a minor or an adult, it puts a person at a high risk of committing.
Okay. Yeah, and that's current law, and that's not even being proposed as a change in your amendment. So I think we should stick to the issues that we're discussing as far as what your proposed changes are in your amendment. You guys can work on that. Are there any other questions here at all for anybody? Okay. I think at this point we could probably maybe recess, and you guys will work on a amendment together that probably works together, and let us know, and we will schedule another work session and see if we can't come to an agreement on that and hammer that out. Does that make sense to everybody here? That's right.
I've got this sort of on my computer at home, and we're gonna
Thank you.
work out if the committee decides that we want to make some changes to the background check thing. I hope you don't, for the reasons that Representative Purple said. If you do, if you let us know, we'll put that in too.
I would rather deal with that as a separate bill next session. Anybody has an issue with that, we can work together on that.
Again, because that's currently in the statute, so there's no issue to deal with it. Yeah. Thank you.
One more thing, to the extent that you can share your amendment with us before the next work session would be great. I think my goal would be to make sure that we get this through as a unanimous recommendation, and that will take some work behind the scenes.
Okay. And with that, I'll close this hearing.
Good morning. Welcome to the public hearing for the Criminal Justice Committee. If you would, please join us in saying the Pledge of Allegiance before we begin. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. And with that, I will recognize Representative Horgan to introduce his bill. Huh? Yeah, I didn't want to.
Okay, thank you. Thank you very much. I'm Resident Timothy Horrigan from Stratford County District 10, which is the towns of Durham. And I see my former colleague, Dr. Joe Hannon, has put in a pink card, and we served adjoining communities for, I can't remember how long it was, but like it's good to see him again, as always. And this bill, HB 191, it's relative to voluntarily surrendered firearms. And it's essentially undoing a bill that was passed a long time ago, back in 1998, which is before I was in the legislature, and was signed into law by the governor. And that governor, by the way, even though she's a Democrat, I still think she made a mistake, and so I'm free to disagree with on her. It's Jeanne Shaheen, who's now Senator Shaheen. And so they added RSA 159.25 to the law book. So that made it illegal for the state police to run voluntary gun buyback programs. In fact, it went a step forward by forbidding any state agency to destroy any voluntarily surrendered firearm. And I don't know, I believe that would apply also to county sheriff's departments and local police departments, since I think they would qualify as state agencies. So I don't know if that's ever been tested or not, if any have tried to do it. So since the law was passed, gun owners may still in theory have the right to destroy their property, but they cannot rely on the state police or any other state government agency to do so safely. And according to an April 9th, 1995 New Hampshire Sunday News article by reporter Sissy Taylor, who later worked for the New Hampshire Speaker's office, state police at that time had a simple and easy procedure for safely destroying a gun, and I assume they still know how to do it. And I guess at the time what they suggested was, well, you can go to a local gun shop and do it, but that's, it's, if somebody has a gun they don't want, and maybe they're not, serious gun owners, maybe they're not used to hanging around gun shops, they may not even know where a trustworthy gun shop is, or even maybe not feel comfortable if they've been the victims of some sort of trauma. Ironically, since this is an old bill, it's easier to track down the bill files than it does for recent bills. If you ever want to know what happened to a bill that happened last week, it's really difficult to find the bill files, but they've digitized all the bill files for this one, including SB 65, 1998, which is the bill this is overturning. And it was they had a very familiar name as the prime sponsor, which was Senator David Wheeler, now the executive counselor Wheeler, and also the former chair, longtime chair of this committee, David Welch, turned up in the debate, and he actually had kind of a strange story where he, what it says in the bill file, he said he told the story about a woman who accidentally shot at a building. His firearm was seized and remained in custody for 4 years. She voluntarily gave it up to police to buy or keep or sell. Reverend Welch bought the gun and has had it 3 years, thus a successful outcome. And that was his argument against passing the bill, that it would have been really terrible if that wonderful, beautiful gun had been destroyed instead of finding a loving home at Representative Welch's. And he was a good man. I can just imagine how he must have sounded when he was saying it. It was probably kind of funny, but in my mind, it's a strange thing. And also, mentioned that Dr. Joe's here. He's apparently representing gun owners of New Hampshire, and they were an organization. They've gone through several lobbyists and spokespeople over the years, but they were instrumental in stopping the voluntary buyback program. And so that's, And actually, there's another familiar name associated with those was Ann Lysak from Portsmouth, whose husband was professor at UNH, and my parents knew both Ann Lysak and her husband, Dr. Richard Lysak. He was shot on Maplewood Avenue in Portsmouth near his home for really no good reason by a young person who had a firearm, and they became gun safety. So she became a gun safety advocate after that, and she was led the opposition to the bill, which was not successful. But I still think banning the destruction of voluntarily surrendered firearms was a bad idea. That's something that the state police and other state agencies should have as an option, and even voluntary gun buyback programs, I think, might be a good idea. Although there were, and so that's the other going on probably pretty near my 5 minutes anyway. But so what this bill actually is going to do. It's first of all, this RSA 15925, which has not been amended since it was passed back in 1998. The first line was no state agency shall operate a firearms, quote, voluntary surrender and destroy program. So that just crosses that out. So now state agencies can operate firearm voluntarily surrender and destroy programs. And then also the rest of it is the same, except then we add a third option, which was or destroyed by the state agency in bold, so that it adds that as an option. And I guess when I drafted, I figured those were pretty much their three options, although I suppose there is also the option of donating the guns. But perhaps perhaps for use by firearm safety programs or whatever. But so that's. But anyway, so that's just now they'll have the third option of destroying the firearm, which now they're not required to do. And I don't know, they get a huge number of voluntarily surrendered firearms. The testimony back in 1990 was usually about 2 or 3 a year, but still they're keeping two. I assume there's probably continuing at a similar pace or more because there's more guns on the street now. So there's probably like several dozen firearms just sitting in the warehouse that they don't want to sell, they don't want to put in their own use, and they may as well be able to destroy them, especially if they're used in some particularly upsetting crime. So, and so finally, just the last two lines in my written testimony is there were too many guns on the streets in 1998, in spite of what some of the people who supported that bill believed, and there are even more guns on the street than now. So I say there's still too many guns on the street, and so I think this bill would be a step to, reducing the number of guns on the street. So I urge you to. I know that's not necessarily a universally popular position on the committee, but I think I think we can get a majority of the committee and the full House behind this pretty simple idea. So that's why I urge you to pass HB 191. Thank you.
Thank you. Representative Prue has a question.
I'm thinking that you should add municipal and county along with the state. That way you're making sure you're grabbing everybody, whether it's a local police department or the county sheriff. That way they're definitely in that group that has to turn them into the state for the auction. Oh yeah, I would view that as I'd view that as a friendly amendment. I see you're scheduled to exec it this afternoon, but that's a simple amendment. So you could probably get that in an OLS, or you could put the bill off and exec it on some future dates. It's not, to the best of my knowledge, an early bill. So thanks.
Representative Stone.
Thank you, Mr. Chair. Thank you for taking my question. Are you aware that a lot of local agencies will utilize FFLs to handle final disposition of firearms that's in their custody?
What's FFL? Would you explain a little bit more?
That'd be a federally fire licensed dealer.
Well, sure. I guess I'm aware of that. And that was, I read the whole bill file. They often mention you could take it to a gun shop, which I guess an FFL. I mean, but then the state police also have the state police have the capability to also destroy guns. They were doing it in 1995. I'm pretty sure they haven't forgotten how to do it, especially the state police is an institution with a lot of institutional memory, and also probably some of the officers who were around back then are still serving now. So I think if they could do it 30 years ago, as almost 30 years ago, they can probably still do it now. And I think that might be more efficient in some cases than bringing in the firearms dealer. Thanks.
Representative Newell.
So to be clear, it's just saying that, that this is possible. It's just giving options for what to do with voluntarily.
Yeah. So they can destroy the surrender firearms themselves, and they can also, if they so choose, have a voluntary, surrender, destroy, or gun buyback program too. So,
Okay. Thank you.
Thank you for your testimony this morning. The chair recognizes Mr. Blackton.
I asked to hightail this bill. New Hampshire is in need of any funds, as we see at White Farm surplus sales. As an FFL, I have had people and families call both local and state police asking what to do with the state firearms once somebody in the family has passed and they no longer want the firearms. They have been told they can be turned into the state police, who can dispose of them. And it is not always told to them that they will be sold at auction or used by the agency, just that they will take them. I often end up with these firearms, and in some cases sell them for the families for money which is often needed by a family who somebody might not have life insurance, and costs are high, and the sale of those help that. As far as a surrender and destroy policy, I object to that, as it also can be used as an end run to keep lawful firearms to shrink. And some of these firearms may be high sought after collectible firearms or parts guns for older guns, which, if not kept by the agency, should be sold to boost the general fund. The New Hampshire State Police even sell their own replaced firearms, and I have sold those as well myself. So if the state police are selling their own replaced firearms, I don't see an issue that they should sell anybody else's firearms. And I think history, if you look back over the years, that the disarming of the citizenry can lead to bad governmental actions by some if they so choose. Thank you.
Thank you for your testimony. Chair recognizes Dr. Hannon.
You have a timer today? Don't worry, I'll be quick. Good morning, Joe Hannon from Gun Owners of New Hampshire. We're in, as you probably already heard, we are in opposition to this bill, and thank you for the introduction before. I appreciate that. I do, however, disagree with the good gentleman from Durham. Governor Shaheen made a good decision when she signed this into law. First of all, it's a very fiscally irresponsible thing to do, to have something with value that the state could sell to buy firearms for other agencies, to put back into the general fund. Actually, it all has to go to the general fund, but that money can be used for any number of things in New Hampshire. So if you care about anything in New Hampshire, whatever that is, whatever is on your wish list of things, that's just a few dollars less for every firearm that's destroyed. And it's not like there's going to be more firearms on the street necessarily, because if someone can't buy a used one at auction, they're going to probably buy one somewhere else. The gun dealers are going to keep making them if people want to buy one. So I don't see that as a net effect. What you do see is a decrease in the maybe possibly more affordable firearms for people who might not be able to pay more money. Anyone's free to buy a quote unquote beautiful gun from any, from the state. if they're allowed to possess firearms, and if they so wish, they can have it destroyed, take it somewhere else, and if that's their desire, if that's the purpose of this, they can do that. And finally, I'd like to just say this makes about as much sense as book burning. You know, there's no reason to get rid of something that you might not agree with, but someone else might be able to use, or it has value. And that's really all I have to say. I'd be happy to answer any questions.
Representative Newell.
Thank you, Mr. Chair, and thank you for taking my question, Representative Hannan. My question is, you know, I mean, if I wanted to do that, then why shouldn't I have the option to do that? No, I mean, if I wanted to voluntarily surrender it and have it destroyed, then I don't know, that's my choice. I know you may not like, you know, me destroying something like that, and I'm not saying that that would be my choice. I'm just wondering why we would restrict people's options and what they want to do.
Cutting me off. I have no emotional attachment to it, so it doesn't. It's not a matter of, you know, destroying this beautiful gun, as we heard it called. It's a matter of, like I said before, of value for the state. If you want to have it surrendered or destroyed, you could do that any number of ways. You don't have to have the state do it, and the state is losing the money and the value.
Okay, thank you.
You're free to do that. Still the choice.
Dr. Hannan.
Yes.
If I want to destroy one of my firearms, how can I have that done?
Actually, offhand, I believe, I mean, FFL can take it. They can do whatever you want with it. You can say, I want it, you know, cut in half, whatever it takes. I believe, I'm not sure if the ATF does it. You might have to contact them. But, you know, it's not against the law to break your own property. You know, you could break your own as long as you don't make it an illegal firearm when you break. You have certain things could be a problem. So if you have a rifle and you break cut the barrel and it's too short, now you're a felon for doing that. Even if it's a functional even if it's non-functional, if you break the trigger and then cut the barrel short, you've done it. So there are correct ways to do it. Anyone can do it if it's done correctly, but you could have a gunsmith. Anyone can do it for you.
And to your knowledge, is there a shortage of gunsmiths in New Hampshire?
There isn't a shortage in this room.
Good point. Representative Muse.
Are you aware that there are private companies that will destroy firearms free of charge for law enforcement agencies?
Great. I'm not surprised. I don't know them personally, but
do you think the use of those should be an option for our own state police?
No, and for all the reasons I just said.
I'm trying to get to the reason for that. So if they can be destroyed at no cost, and that's the wish of the property owner, what's the issue?
Why involve the state? The property owner can have it destroyed if they like. I mean, I don't understand why the state has to get involved and lose money in the process.
Follow up? Yeah. I would say this state actually already seems to be involved in the disposal of firearms. So currently they are accepting firearms. We've just simply precluded the option of destroying them. So we already have the cost of accepting those firearms, figuring out what to do with them, running auctions and sales and things like that. It seems like adding one more option for the property owner to just simply check a box, and state police pack these things off in a crate once a month and to this company that grinds them up or whatever they do with them. It doesn't seem to be an undue burden, given the fact that the state police already seem to be spending money, time, and resources kind of addressing this issue. Would you agree?
I would not agree. Thank you. And I would say if they don't want to spend the money on an auction and all that other stuff, they're more than welcome to deliver them to me. I'll give them my address if it's at no cost, and I'd be happy to take them off their hands and out of circulation. Right, I know. Sorry.
Thank
After the good representative.
Thank you for your testimony.
Thank you.
The chair recognizes Mary Bonilla. Yeah, no.
Good morning, committee. My name is Mary Benny. I'm the lieutenant with New Hampshire State Police. I've been with them for about 19 years now, a little bit over. Just here for not to weigh on one side or another, just what it would take with us, because it will be something we have to reintroduce into our organization in order to have this process go forward, and how we would do it and make motions to the court, because we don't just destroy anybody's firearms without the court giving us that kind of permission to do it. So it is going to be a little bit more intense on our side in order to do more reports, more motions in order to destroy them. Of course, we have a concern that if anybody walks in with a firearm, once it's sold from the FFL, a private sale to a private sale, you don't know who really is the actual owner of that firearm, and was that firearm used in a crime at some point, and now we're destroying it. So just kind of things that we wanted to bring to your attention, who that primary owner is. Is it destroyed or gone to auction? Right now, most of them are destroyed, that were used in a crime that we have safekeeping on. It also, with this statute that came forward, unlike the others where we return or destroy property, it doesn't relieve the state of any liability if it is destroyed and someone comes forward later to say, that was my property, not theirs to give you, because we can run into that without tracing these firearms.
Since the law that was signed, that's currently the law, has your agency had a problem with like having so many firearms you didn't know what to do with them and wishing you could destroy them?
We have not had a problem with so many. Our division armorer is in charge of destroying those firearms, so he is the one or his designee of who he chooses to do that when he has that time.
Thank you. Representative Newman.
With the bill as written, where it simply says, it goes on, or it just seems to give the option to do that. There's no requirement in this bill for them to do that. And even if a family wanted to have guns destroyed, I'm not sure what the mechanism would be to try and get the state to do that, but the law does not, just gives an option. So would that affect the way you did, as you described?
I'm not really understanding your question.
The law itself does not direct the state police to destroy voluntary firearms. It only says that that is an option, even if they came from a voluntary sale. And I don't know if there's another law that applies to that, but right now I don't see that it would. It's my belief that would that cause you to additional work if you just had that option?
To destroy them.
Yeah.
It will provide some additional work, because we have to write a report on everything that comes in, along with get that motion from the court in order to move forward with that destruction.
Follow up. I don't see in this law that the court has to be involved in that. You're saying every time that the state police destroy a firearm, they need a court order to do it for every single weapon?
That's what we do, yes.
Thank you.
Thank you for your testimony.
Thank you.
Could you, maybe you already did, leave your information so that if we have any more questions on this, we could reach out to you? Thank you. Anyone else here wishing to testify on this bill who has not done so? Seeing none, I hereby close the public hearing. And the next one starts right now? 10:15. Okay. We're in recess till 10:15. This time, I'm open to public hearing on House Bill 305 and recognize Representative Mannion to introduce this bill.
Thank you, Mr. Chair, members of the committee. I'm here to introduce HB 305. I represent Hillsborough 1 Pelham. So last year, I watched the testimonies of last session's House Bill 1178. There was a lot of talk about this week. I know you guys are probably sick of seeing me. And the concerns of Granite Staters about the language of the amendment to the bill, they responded to me. With the current language, RSA 159E2 reads, "Nothing in this chapter shall prevent a state, county, or local official from cooperating or rendering aid or assistance to federal officials with in any circumstance where there is reasonable suspicion to believe that a person who is a subject of an investigation for violation of federal firearms laws covered by RSA 159E2 has also committed, is committing, or is about to commit a violation of New Hampshire law or a violation of a federal law, regulation, order, or practice not covered by this section." So it says a violation of a New Hampshire law, which is extremely broad. But what is worse is a violation of federal law, regulation, or order that nullifies the entire purpose of the bill. If you've ever seen the @CrimeAday Twitter account, you can see where this exception is very wide. We commit however many felonies a day is the joke, right? So we're constantly in violation of some federal law if you dig deep enough. So my language here simply scales back the exception to what I believe the original intent to be: to prevent violent criminals from using the non-cooperation language of 159E as a shield for New Hampshire law enforcement. With that, I'll take any questions. It's real. It all does is strike one line and make it shorter in the existing RSA.
Representative Muse.
What I'm trying to get at is what are you trying to accomplish here? What problems do you think that this bill will solve?
So the existing law right now has a massive loophole that it basically nullifies the entire purpose of the what we consider the gun sanctuary bill. So if an individual is committing any crime under the sun whatsoever in New Hampshire or federal, which is, if you dig deep enough, you're committing a crime right now by breathing the wrong amount of air or whatever it may be. This scales that back to make it so it's very clear it has to be a Class A felony that the person is committing for our law enforcement to cooperate with the feds to enforce unconstitutional gun laws.
Follow up? And my understanding is that this particular law applies to firearms.
Correct.
And Second Amendment issues. So off the top of my head, how many firearms related violations in New Hampshire are Class A felonies? Can you give me a couple of examples?
Well, it would be specific, like they're not necessarily firearms related. The way that the law is written right now is it says that they can cooperate if any other violation is occurring. The reason this amendment was originally added to the 1178 bill was because, from my understanding, is the Attorney General wouldn't sign off on it because the way the language was originally written is sounded like if an individual was committing a federal firearms law violation, our law enforcement were not allowed to cooperate with the feds because we had the way the law was written, it basically shielded the criminal. So if they had like a machine gun and were committing human trafficking, we couldn't help because they had the machine gun and we're not allowed to go after anybody who's violating or who isn't violating a New Hampshire gun law.
Follow up, please. Would your change preclude New Hampshire then from assisting a federal officer with a kidnapping that crosses over state lines?
No, I do not believe so. I'm almost certain that so I'd have to go back and look at the RSA, specifically defining all the Class A felonies as defined by New Hampshire RSA. And I believe trafficking or kidnapping is on those.
But other federal crimes that are non-firearms related, there would be a preclusion from also assisting with those.
I stripped the feds because the feds tend to move around like definitions of penalties and crime severity. So
Thank you.
I didn't want to be subject to their whims.
Could you give the committee an example of a case, or not a real case, even a hypothetical
Yeah.
case, where you think this law should apply? Give us a scenario for the folks so we can actually understand what this law should accomplish.
So the existing law that's on the books, as a hypothetical, let's say that I had a suppressor, like I self-manufactured a suppressor because I'm trying to protect my own hearing, and I didn't go through the process of getting a tax stamp. Right now, if I had a suppressor but was also technically growing a marijuana plant or something along those lines, or not a marijuana plant, but it had marijuana with, so it's not a criminal violation here, then the fact that I had marijuana and that's a violation of a federal crime or federal law, our local law enforcement could help the ATF in enforcing the tax stamp violation that I committed. Right now, the law makes it now, so just because I have marijuana, that's not good enough excuse to bring in our state and local law enforcement to help the ATF enforce that unconstitutional law.
Thank you. Representative Newman, I sense a question.
Thank you, Mr. Chair. Thank you for the question. For taking my question. I believe I've heard you say a couple of times that this law prevents New Hampshire police to assist the feds in an unconstitutional gun law. And I'm curious if you can give me an example of exactly which gun laws that have not been deemed unconstitutional by the Supreme Court, which ones that are currently in force, how can you say that they are unconstitutional to the federal constitution?
Right. The bill doesn't specifically say I'm using my own opinion of these laws. Shall not infringed is quite straightforward, and I think anything that infringes is unconstitutional by my definition.
Okay, so it's just your opinion.
Yes,
It's
that's
not
my
the
opinion.
fact. You're not saying that the federal laws that have not been overturned by the
That's correct.
Supreme
I
Court.
apologize for the being unclear.
Thank you very much.
Seeing no further questions, thank you for your
Thank you.
testimony. Chair recognizes Representative Horgan.
Thank you very much, Mr. Chair. I continue to be resident of Timothy, Oregon. I continue to represent Stratford County District 10, which is the towns of Durham. And I hope our colleague Representative Selig gets well soon. She's watching on YouTube. At least she was watching the previous hearing on YouTube. So, and I was glad the member refreshed my memory that it was HB 1178 because which I thought that's what this is about. And I was a little going nuts because this RSA 159E, which is what was established by HB 1178, is not listed in the bill, not yet listed in the bill database. So that's just thought I'd mention that. I'm sure there's other RSAs we have that problem with. So I think the sponsor of this bill, I think, pointed out the whole premise behind HB 1178 was irrational. Like, there's, just about any federal offense, if the person owns a firearm, can become at least in part a firearm offense. And I personally don't think that's. I don't think there's anything wrong with that. I don't really know why guns should be treated separately from any other dangerous thing. And certainly, HB 1178 has created a lot of irrational situations. Like, for example, here in my community, we have a new middle school that has a lot of security precautions. But if somebody gets through the security precautions with a gun, the school's not quite sure what they can do aside from putting the lockdown. Whereas, say if the person came in with a suicide vest and a bomb, I guess that's not covered by the Second Amendment. If you're waving a chainsaw around, that's obviously not covered by the Second Amendment. Or if you barge into the ladies' room, that's not covered by the Second Amendment, unless of course you're wearing a gun while you do it. So there's lots of there's lots of situations. So I'm not sure, so like where they at least feel like they're hampered in the ability to deal with certain types of threats that they might reasonably expect to have, and certainly it makes it a lot harder to take preventive action. And there's a myriad of things like that, and also presidential executive orders. I'm not a big fan of them, but they are necessary sometime. And the current president is not the only one who's issued executive orders governing the keeping or bearing of arms. So the previous one did too. He put out an executive order after a massacre in Las Vegas banning bump stocks. And the people who are so worried about the current president's executive orders were not worried about that president's executive orders. And I understand that's how it is when it's your guy. Just like, I voted for the current president, so I'm inclined to cut him more slack than if it was a president I hadn't voted for. So that's fair enough. So I just sort of, so I think, I think the sponsors bill has indeed seen an illogical element of the bill that we passed last year, and I think the best solution, although this would be a germane amendment to this bill, there is another bill that just eliminates the whole HB 1178 RSA 159E. So I think that's probably the better way to go rather than trying to fix in this bill. One last thing, we already have a big problem in the court system, and I serve on the Judiciary Committee, so I'm made aware of this on occasion. Is that we have a problem with overcharging defendants. So this will encourage the police, if they're investigating something and they think the person has a firearm, and probably just about anybody might have a firearm, they'll start charging people right off the bat with Class A felonies, even if they don't think that's what an appropriate charge. So we already have enough problem with overcharging people, and this is just going to encourage our police forces to maybe even charge everyone who's doing something suspicious who might be going to trial with a Class A felony, just so they can continue to work with the federal officials. And it's certainly not, and as I said too, it's certainly illogical to single out firearms laws. They're no different than like anything else that's dangerous in our society, and they should be treated the same way rather than be given this sort of special status that we give them. So I think I probably urge you, probably your best course of action is probably to retain this bill, and then in case the HB 78, the HB 115, which repeals this whole law, passes, and fails, you can use that as a vehicle for further action in that area. But I don't see nothing good really can be accomplished just by this one change, even though it seems like a simple change. So thanks. That's what I had to say about it. And I guess I'd be happy to take any questions, although.
Thank you for your testimony.
Thanks. I apologize for getting too partisan, but I just felt I had to make the point. Thanks. Great. Thanks.
No worries. Anyone else wishing to testify on this bill? You sure? Are you sure? There being no others, I hereby close the public hearing on HB 305, and the committee is now in recess until 11 a.m. Morning at this point, we are opening the executive sessions, and we are starting with the executive session on House Bill 31. And I recognize Representative Prue to make a motion. A second?
I'll second, Mr. Chair.
Representative Jannery was doing that. Oh. Okay, would you like to speak to your motion, Representative Prue?
I think these are mostly antiques and what have you, but, again, they fall, I believe, under the Second Amendment to be able to protect myself if so needed. I mean, most people can carry a gun now without a permit, so something to carry in your pocket, I'm okay with.
Would you like to speak to your second?
Thank you, Mr. Chairman. No.
All righty. Discussion. I will just start by saying that this is just an antiquated statute. There are far more lethal things available today than these, as Representative Prue so aptly put, antiques. So I just don't see the need to keep them in statute as prohibited. But anyone else? Representative Gathright.
I have a real concern for this bill, and particularly for students, high school, middle school. I think the law is in place for a reason, and it's been there for a very long time. And when you think about the, what they call this, the slung shots, very dangerous weapon. That's the one that has the balls on the end of it. You can throw them like this. And no, that's what it is. And I just think that it's a very, can have quite a few unintended consequences if we were to pass this bill. So I will not be voting to pass such a horrible bill.
Okay. Representative Muse.
During the testimony, we did hear these framed as antiquated, non-lethal defensive tools. When I actually looked up things like brass knuckle injuries in Google and looked up injuries from some of these other things, what I found is these aren't just being kept on a shelf and treated like antiques. There was a video that I saw of a woman who was sitting parked at a traffic light. Somebody using brass knuckles shattered the window of her car, assaulted her, punched her face, pulled her out. And the difference, which was shown in the video, between what her face looked like before that assault was committed on her and what she looked like afterwards was horrifying. These are weapons that can you imagine if people started taking them into bars, started getting a little intoxicated? Imagine a situation where police had to go into a bar after some kind of disruption and and try to arrest people who were wearing these and who were using them. Passing this creates a huge potential can of worms for New Hampshire. It creates a can of worms for our law enforcement personnel. We have a statute that may not be used that much right now, but the fact that it's there may be keeping people from doing some of this stuff and using some of these things against other people. And to me, that's a perfectly good reason to keep the statute on the books. And so I will be voting against the motion of ought to pass.
Thank you. Representative Mannion.
Thank you, Mr. Chair. We have laws in place for the use of these weapons. This is just a possession of these weapons, so that wouldn't change if someone were to use these in a manner that violates another statute. However, if I was that woman in the car, I would have loved the opportunity to have a pair of brass knuckles on myself to defend myself against that attack. Thank you.
Thank you. Actually, that reminded me of a commercial I saw not too long ago on television where they were marketing apparently to women some kind of claw device that a woman could use to defend herself. And I don't think that would fall under these descriptions, but it had like made you look like that guy with all the blades on his finger from the Marvel movies. So that there's that. Swords are illegal. This is just several things, but there's still a whole plethora of things that are legal. So my support was based on the fact that it just narrowly these things. But anyone else? Representative Janvard.
Thank you, Mr. Chairman. I'm of the opinion that our Second Amendment in the United States Constitution guarantees us the right to bear arms. These are clearly arms, although antiquated. And to speak to Representative Muse's concern, I just looked up RSA 631-1, first degree assault. Person is guilty of a Class A felony if he, I'm going to the second one, purposely or knowingly causes bodily injury to another by means of a deadly weapon. So it's already illegal to use it in an unlawful way, and possessing it is not using it in an unlawful way. It is a defensive weapon. If it's used as an offensive weapon, it is then a crime. So I support the OTP.
Representative Sytek.
I'll waste just very little of the committee's time. My understanding is the Twin Towers were brought down with box cutters.
Okay. Anyone else? Seeing no one else, I will ask the clerk to call the roll.
Vice Chair Rhodes?
Yes.
Representative Pratt?
Yes.
Representative Sytek? Representative Prue?
Yes.
Representative Janvrin?
Yes.
Representative Mannion?
Yes.
Representative Reed?
Yes.
Representative Stone?
Yes.
Representative Tenzar?
Yes.
Representative Harriet Gathright? Representative Muse?
No.
Representative Bolden?
No.
Representative Bradley?
No.
Representative Murphy?
No.
Representative Newman?
No.
The clerk votes no. Representative Newell?
Yes.
Representative Nutting Wong?
No.
Chairman Roy?
Chair votes yes.
Motion passes 11-8. Yeah.
Chair, could you say the vote again, please? Thank you.
Motion passes 11-8.
11.
With that, I close the executive session on House Bill 31. I open the House executive session on House Bill 89. And I will recognize, actually, myself. I will be offering an amendment, House Bill 89, and it is amendment number 0370. I believe oh, that's the wrong one. Wait a minute, which one's this? Oh, this amendment has not yet arrived from OLS. I'm going to recess this, and we're going to pick it up in a little bit once I'm able to check with Karen. There's an amendment on the way. I am going to open the executive session on House Bill 158 and recognize Representative Stone for a motion.
This is on 158?
Yeah.
I would make a motion to ITL this bill.
Okay. Second?
Second.
Would you like to speak to your motion?
Mr. Chairman, I would. This bill as presented would turn thousands of law-abiding citizens in New Hampshire into felons. A large majority of common hunting rounds can penetrate ballistic vests and / armor in its natural course. Therefore, I feel this bill has really no value for public safety.
Representative Mannion?
I concur with Representative Stone.
Discussion. I'll start off. I just would say that the police haven't asked for this. The definition is really confusing, and it would, in fact, make many rounds that have no relation whatsoever to the subject matter become felonious possession just because they're hunting rounds. The bill, if it were to be worthy of passing, needs a lot of work, and we're just not doing that right now. So, Representative, who's we have a list? Oh, Representative Rhodes.
Thank you, Mr. Chairman. I would just like to add that while the sponsor, I believe, had good intentions as he was here with the testimony, there was a lot of questions that were not able to be answered, and one of the one that is glaring in my face is if this were to pass, then what happens with the ammunition that people currently have? And that was just, well, I guess it would be phased out over time, but I think we all know exactly how that would be implemented, and again, it was not able to be answered. So I just think that I agree with the ITL motion.
I would also add, and I didn't, I should have. This is true armor-piercing ammunition is already federally illegal, and possession of it is a federal felony. And that's the stuff that really does actually designed and made for piercing body armor, and it is used for military purposes. Further discussion. Representative Murray.
Thank you, Mr. Chair. I just wanted to point out to the committee that the definition used in this bill was pulled from an existing RSA. So while I agree with the ITL motion, I think that maybe we should examine that RSA in the future to provide more clarification.
Thank you. Good point. Anyone else? Being none, I'll ask the clerk to call the roll.
Vice Chair Rhodes?
Yes.
Representative Pratt?
Yes.
Representative Sytek? Representative Prue?
Yes.
Representative Janvrin?
Yes.
Representative Mannion?
Yes.
Representative Reed?
Yes.
Representative Stone?
Yes.
Representative Tenzar?
Yes.
Representative Harriet Gathright?
Yes.
Representative Muse?
Yes.
Representative Bolden?
Yes.
Representative Bradley?
Yes.
Representative Murphy?
Yes.
Representative Newman?
Yes.
The clerk votes yes. Representative Newell?
Yes.
Representative Nutting Wong?
Yes.
Representative Wheeler? Chairman Roy? Motion passes 20-0.
Motion passes 20-0. Consent, no objection heard. I hereby close the public hearing on, the executive session on HB 158. Open the executive session on House Bill 216. And I recognize Representative Muse for a motion. Take your time. Motion by Representative Muse, seconded by Representative Gathright. Representative Muse, would you like to speak to your motion?
Yes, I understand that there are folks who believe that this drug should be exempted as part of harm reduction strategy. However, I don't believe in that simply removing it as a controlled drug under the Controlled Drug Act would actually accomplish harm reduction. I think what it would accomplish is a lot more people taking a drug that should probably be taken under some type of medical supervision, if it's going to be taken at all, in situations where they may not have help available to them. One of the things that we heard during testimony is that while there are a substantial number of people who seem to get a benefit and derive some type of psychological benefit from taking this drug, we also heard that there are other people who have bad trips and where there can be significant consequences to taking a drug like this without some type of help being nearby if something goes wrong. So I uh, I am sympathetic to the idea of decriminalizing some things in our Controlled Drug Act, but at this point in time, the way this bill is written, this would not be one of them.
Representative Gathright, would you like to speak to your second? Further discussion, Representative Newell.
While I am very much in favor, thank you, Mr. Chair. While I am very much in favor of decriminalization and regulation, I think that those two things go hand in hand, and I think that there's a process for that, and concur with what Representative Muse Gaithright said.
Thank you. Representative Wheeler.
I think that adults should be able to make the decision of to be stupid, to be weird, or to have a bad trip if they so choose. And I think the state stepping in and saying that you're not allowed to take a drug which the only harms I could find online in research or we were told about were, as Representative Muse said, a bad trip. And I think that's not a significant enough harm. It doesn't harm another person. And if someone isn't harming another person with their choices, then they should be allowed to make stupid decisions. So I will be voting against the ITL motion.
Thank you. Representative Sitek.
We heard testimony that this was not addictive. When I heard the state police had their opportunity to speak, they had very little to say. It was just a general dislike. I think next, are we going to if there's no addictive properties, are we next going to outlaw pleasure? So I'm going to be voting against the ITL.
I believe pleasure has already been outlawed at the federal level. Anyone else? Oh, Representative Prue.
I appreciate you trying to keep my job and working, because I'm the one who gets the bad trips, but I'm still going to vote against it.
Thank you for that. Seeing no one else, I'll ask the clerk to call. Oh, who did I miss?
Can I just add one more thing for the record?
Absolutely.
This drug was legal to buy online until 2011 in my research. I had a few questions and no one could answer that too well, but in my research, it was legal to buy online until 2011, and we hadn't had a problem until the federal government decided to step in and make it illegal for no well-documented reason.
Hence my comment about pleasure being unlawful. Representative Muse.
One thing I would like to point out is the court has basically ruled, according to the testimony that we heard, that it is still legal and appropriate for people to use this drug for religious reasons. And nothing about ITLing this bill would actually change that.
Thank you. I will at this time ask the clerk to call the roll.
Vice Chair Rhodes?
Yes.
Representative Pratt?
Yes.
Representative Sitek? Representative Prue?
Yes.
Representative Janvrin?
Yes.
Just as a reminder, the motion is ITL. Representative Mannion?
Yes.
Representative Reed?
Yes.
Representative Stone?
Yes.
Representative Tenzar?
Yes.
Representative Harriet Gathright? Representative Muse?
Yes.
Representative Bolden?
No.
Representative Bradley?
No.
Representative Murphy?
Yes.
Representative Newman?
Yes.
The clerk votes no. Representative Newell?
Yes.
Representative Nutting Wong?
No.
Representative Wheeler? Chairman Roy?
Yes.
Motion passes 15 to 5.
We have a count discrepancy again.
Yeah, 14-6.
Okay, you said 15-5 at first.
Yeah, it's 14-6.
Okay, 14-6 is the correct. The result is, the motion carries 14-6 for the record. At this point, I close the executive session on House Bill 216. I open the executive session on House Bill 315, and I recognize Representative myself as a motion, as for. This is, I would like to introduce an amendment, and now it's the amendment 0370H, and I'll speak to the amendment. The amendment does not do anything to the bill that was brought before us, except for it adds an additional line, and it says, the provocation was not objectively reasonable if it resulted from the defendant's hostility to a decedent's religion, race, creed, sexual orientation as defined by RSA 21:49, national origin, and this is the part I added, political beliefs or affiliation, or gender identity as defined under RSA 2154. The reason I added that is because in the climate we're seeing today, we're seeing politicians, non-politicians, people getting shot, getting killed because of their political beliefs. And wherever we have a chance, we have to reiterate our First Amendment and our rights to believe the way we want. And I feel like this is a good spot to start. And since the sponsor was kind enough to bring this to my attention, I believe that gender identity and the whole gay defense thing is outrageous, and it shouldn't be used. Generally speaking, I'm in favor of the court being able to decide that. But sometimes we have to, as a legislature, let courts know the mind of the populace, and that's where I stand in that.
Mr. Chair, you need a second.
I thought you seconded it. Can anyone retroactively second that for me, please? Oh, okay. Okay, it's been seconded. Thank you. Discussion. Representative Muse.
One of the things I think that I'm wondering is whether the amendment accomplishes the original intent of the sponsor of actually prohibiting a gay panic defense. And another question would be, are we opening the door to a Democrat panic offense, a Republican panic defense, a racial panic defenses? I mean, I'm trying to kind of understand, is the amendment actually germane to what was originally proposed, or are we actually enacting something very, very different?
Well, as I left the sponsor's language intact except for additions, so the sponsor's intent is not affected as far as I'm concerned, and it only expands upon it. And if we look at what's already there, we had race, creed, sexual orientation. We added sexual orientation. We had race, creed, national origin, all of the things that people. So, did we already have a race panic? Did we have a religious panic? I think that if we're going to extend this protection as a society, we should look at what's happening in our current time. And right now, we see political violence on the rise. So whether or not it's going to be a panic defense or any defense at all, it should not be allowed as a defense to killing someone. So that's the reason for the addition. I do not think it takes away from, it simply adds to taking away the gay panic defense, and also adds to that political beliefs. So that.
And follow up?
Sure, absolutely.
Yeah. So you had said you're basically saying that the amendment doesn't replace any language; it actually adds language. But there is language in the original bill in Section 4. For instance, that does say that if the provocation was not objectively reasonable, it says that basically the provocation is not objectively reasonable if it resulted from the discovery of knowledge about the potential disclosure of the victim's actual or perceived gender, gender identity, sex, or sexual orientation, including under circumstances under which the victim made an unwanted, non-forcible romantic or sexual advance towards the defendant, or if the defendant and victim dated or had a romantic sexual relationship. There's also some additional language that says in section 4 that says nothing in this paragraph shall preclude the jury from considering all relevant facts to determine whether the defendant was in fact provoked for the purposes of establishing subjective provocation. There's also a section B that that defines gender for the purpose of the paragraph. So I'm a little confused because the amendment actually seems to eliminate a lot of language that was in the original bill as opposed to just supplementing it. And could you comment on that?
Yeah, I would actually. The language, the purpose of the bill was to defend, or was to prohibit the gay panic defense, and that's clearly still here, the sex or gender, without getting into, as the original bill did, about dating and into the nature of relationships. In my opinion, it shouldn't matter what the relationship is. If you kill someone and say you did it because they were gay, whether you were dating or you surprised them or what you did is, in my mind, irrelevant. You killed someone, you're trying to get away with it because you're saying they were gay. So I did remove the part that described relationships. As far as the gender identity, it's already in statute in RSA 21:54. So that a purpose, having it in there for the purpose of the statute, we can't have conflicting definitions. We should have one definition in statute if we're going to define something in statute. So having different chapters with different definitions of the same thing is not helpful. So again, I would go back to the intent of the sponsor was to alleviate or remove the gay panic defense. This does that, and it just makes it a little broader without putting in language that is so specific to a certain scenario that it narrows it so much that it's not able to protect anyone else except for those specific people in those specific scenarios. Representative Manning, you had a comment? Or did you have your hand up? Oh, who had their hand up? Representative Reed.
Thank you, Mr. Chairman. I felt the original bill was very narrow, so when I heard the amendment, I was much more comfortable with passage with the OTP. I felt it was made better and more inclusive by adding all those other components. So I like the amendment very much. Thank you.
Murray.
Thank you, Mr. Chair. While I appreciate the intent of the amendment, because I do agree that we need to make sure we protect all people from these kinds of defenses in court, my concern is that there is legal precedent of the gay panic defense being used specifically in these situations where there's surprise, dating, relationships involved. And because there's that legal precedent with those specific group of people, and to my knowledge, there's not that same legal precedent where people have been able to say, oh, I had a momentary burst of insanity because of someone's religion, and that has ever been used, to my knowledge, in any case, whether successfully or not. It's two very different issues, and I think it would be more applicable to the intent of the bill and also clearer to those enforcing this law to be specific about what we're trying to prevent, and then in the future we can do a different bill which addresses these other categories that we also want to protect. But I think that this muddies and waters down the original intent of the bill and could possibly still leave a loophole that would be abused in the future.
Thank you. I would respond to that. I recall, I'm old enough to remember after 9/11, there were quite a few people that were taking action against people of the Islamic faith, and they panicked because, oh my God, are they a terrorist? And some people were indeed hurt by that. Further, we have to, in my opinion, as a committee and as a legislature, we don't pass laws to send political messages. And if the intent was this, we want to send a message, and we're going to get so specific. Either the bill or the law is to protect people, and we enumerated certain groups of people. then it's to defend those people. The message or the intent isn't the reason we make law. We make law to protect people. And I agree with you. It has been used in other jurisdictions, never in New Hampshire. And it was not successful, the gay panic defense, or hasn't been in quite some time. So the argument could be made it's really not needed. However, having said that, to protect from it ever happening in New Hampshire, we're saying let's pass this. I say at the same time, why come back later when we have a chance right now to protect all of these people in these classes from anyone having any kind of excuse where they think they can get away with murder because of someone's religion, someone's race, or all these things, or someone's political beliefs. But again, we are all free to. Representative Sitek. Time, Representative Newman.
I just have a question. You mentioned the bill that that the definition conflicts with, but I did not get the number of the bill, and I'd like to see if they are comparable or if two different definitions are appropriate. Is it in the amendment? I say, okay, thank you very much. I see it's on there. Thank you.
Representative Bolden.
I just wanted to throw in just food for thought that I think historically it's easy to forget because we live in this world now of like we have rules, we're a nation of laws, and we grow up thinking we know what is expected of us, and that murder is always improper, that physical violence is always improper. But it wasn't that long ago that cultural perspectives were different, and that those differences in cultural perspectives were used to justify violence, but they weren't capitalized on to justify violence. They genuinely justified violence in those cultures in prior versions of this country. I'm sure you've all heard about old laws about like maybe the thickness of the whip you can use on your wife, for example. And we know that there's been shifts over time about physical punishment of children. And I think most recently, where that translates is there's, I guess, the most prolific serial killer. I think his name was Sam Little. He specifically targeted sex workers because he knew that they wouldn't be valued. And he argued when he was caught from time to time, he would say, well, she was stealing money from me, or she wanted to do something weird. And then he was let go by authorities because they found that to be a justified reason for whatever his violent outburst was. So there are people alive today who do take into consideration your reasoning for a violent act. They don't think that it's black and white the way that some people may think it is today, that you just shouldn't be violent. And their own biases do go into their evaluation of your behavior. And I just wanted to throw that out there because the situations in which the bill at hand would be important are going to be very, maybe even singular situation, if ever, hopefully, right? Maybe never, but it would be a very complicated situation in which someone lost their life. And I hope that we can make decisions with that in mind. Thanks.
Thank you. And that reminds me of one other thing. We just in this committee discussed the other day about needing to do a certain thing because there are continuously new residents coming to our country from different places who bring with them their biases and culture ideas. And until they can acclimate to our own, things like this, where it may be acceptable for one religion to use violence against another, to clearly spell it out, that is not an excuse in the United States to use violence, or race, or sexual orientation, or your gender identity, or any of these things, or political I just think if we're going to do it, let's do it and make sure that everyone possibly could be covered. Thank you. At that, I'm going to have the clerk call the roll. Just a reminder, this is just on the adoption of the amendment. And the motion was OTPA, or
Is it adoption?
OTP. Yeah,
OTP, the amendment?
adopting the amendment.
That's what I thought was the
Yeah.
motion, adoption. Okay. Vice Chair Rhodes?
Yes.
Representative Pratt?
Yes.
Representative Sytek? Representative Prue?
Yes.
Representative Janvrin?
Yes.
Representative Mannion?
Yes.
Representative Reed?
Yes.
Representative Stone?
Yes.
Representative Tenzar?
Yes.
Representative Harriet Gathright? Representative Muse?
Yes.
Representative Bolden?
Yes.
Representative Bradley?
Yes.
Representative Murphy?
Yes.
Representative Newman?
Yes.
The clerk votes no. Representative Newell?
Yes.
Representative Nutting Long?
Yes.
Representative Wheeler?
Aye.
Motion Chairman Roy?
Thank you. The chair votes yes.
Motion passes 19-1.
At this point, I would like to make a motion of OTPA, seconded by Representative Prue. I think that we've spent enough time discussing it because the motion on the amendment covered the actual bill. I think that there's no excuse to kill anyone. And for anyone who might contemplate making one out of these reasons in the amendment that we just passed, they're not going to be able to. And I think that's a step in the right direction. And I applaud the sponsor for bringing this bill to us, and certainly want to recognize the importance of of killing anyone thinking of using the gay defense as an act of violence. So with that, further discussion? Seeing none, I'll ask the clerk to call the roll. Again, the motion is OTPA.
Vice Chair Rhodes?
Yes.
Representative Pratt?
Yes.
Representative Sytek? Representative Prue?
Yes.
Representative Janvrin?
Yes.
Representative Mannion?
Yes.
Representative Reed?
Yes.
Representative Stone?
Yes.
Representative Tenzar?
Yes.
Representative Harriet Gathright?
Yes.
Representative Muse?
Yes.
Representative Bolden?
Yes.
Representative Bradley?
Yes.
Representative Murphy?
Yes.
Representative Newman?
Yes.
The clerk votes yes. Representative Newell?
Yes.
Representative Nutting Long?
Yes.
Representative Wheeler?
Aye.
Chairman Roy?
Chair votes yes.
Motion passes 20-0.
Motion passes 20-0. It will be on consent, barring objection. No objection, seeing none. I hereby close the executive session on House Bill 315. I hereby open the executive session on on 473. And I recognize Representative Rhodes to make a motion.
Thank you, Mr. Chairman. I would like to make a motion of ought to pass for House Bill 473.
Second.
Second.
Would you like to speak to your motion?
Yes, thank you, Mr. Chair. We had heard in the testimony in Reps Hall about, for a first-time defense about the criminal penalties and what that does, the impacts of a person's job and or being able to gain employment afterwards. And we are not changing anything about possession or any of that part of the law. This is basically just to, I guess it's almost giving a person a chance for that first time offense to be able to bring things back together and give them a second chance around.
Thank you. Representative Gathright, would you like to speak to your second? I'll start discussion. I brought this bill because, not because I think that we should be weaker on the use and drugs in this state, but because we need to stop making felons. The effects of a felony on someone's life at a young age are almost incalculable. It carries them and follows them the rest of their lives, and it almost makes the hope of redemption and change out of reach, and it just sends them automatically on a mental path where I can never get rid of this felony, and the incentive to better themselves is just taken away. And when I saw the disparity with which this affects communities of color in this state and across the country, I think that we need to stop making felons of our young folks, and when they make a mistake, give them a chance to get help and back on track. And I just don't understand why we would want to continue making these people felons on such a level so quickly. So that's that. Anyone else? Representative Newell.
I would just like to add, I'm absolutely in support of this bill. Thank you for bringing it. And agree with all of the things that you said. Also, I think, we need to make a shift in how we deal with people who have issues with substance use, or, it is a matter of treating people as if they are a part of our community, or otherizing them, separating them, and making them a felon is essentially what you are saying, putting somebody at a disadvantage, putting them outside of our community, and only harm can come from that. So I just wanted to kind of just expand on what you said.
Thank you. Any further comments, discussion? Seeing none, I'll ask the clerk to call the roll.
Motion is OTP. Vice Chair Rhodes?
Yes.
Representative Pratt?
No.
Representative Sitek? Representative Prue?
Yes.
Representative Janvrin?
Yes.
Representative Mannion?
No.
Representative Reed?
Yes.
Representative Stone?
Yes.
Representative Tenzar?
Yes.
Representative Harriet Gathright?
Yes.
Representative Muse?
Yes.
Representative Bolden?
Yes.
Representative Bradley?
Yes.
Representative Murphy?
Yes.
Representative Newman?
Yes.
The clerk votes yes. Representative Newell?
Yes.
Representative Nutting Wong?
Yes.
Representative Wheeler? Chairman Roy? Motion passes 18-2.
It's crackling.
Use the hammer.
I know.
Turn it off, turn it back on.
Oh, this is it all of them?
Testing.
Is that the Goody Cole bill? Is that the Goody Cole bill?
Yes.
Yeah, that's actually what I've got. The House.
Yeah.
Yeah.
Yeah, he had a revolver and he used to shoot the gavel there and yeah, it was made of a chip. It was a good thing. It was kind of cracked. Okay.
I'm not doing anything.
A 1 2 2. Okay, I'll restart the system.
Thank you, sir.
Microphone check 1 2.
Testing. What did you do? What did you do?
So these ones, they're all daisy chain. Typically, it's one comes unplugged a little bit. So, so it could have been anybody. What was it? They're daisy chains. The testifier mic was the booms. So we're seeing that and then we're seeing the chair. That's probably when they pulled it.
We thought it was my Thor hand, but the light.
So that could do it too. Yes. Oh, thank you, sir. Like Christmas lights? Yes. Yeah. Red is on, and yeah. But yeah, you're right. They're all on. Exactly. So it's usually a testifier when it starts. Yeah, you're right. Sure. Somebody made a poll. I'll put lights in. Here,
Testifier bike 1 2.
You know what, that one, because it was unanimous.
Testing.
Okay, at this point, we're going to resume our executive sessions. And at this point, I'm going to open the executive session on House Bill 89 that we shortly recessed while we waited for an amendment. And I'm going to recognize Representative Muse to make a motion.
Thank you, Mr. Chair. I would like to move Amendment 2023-0472H to pass.
There's, it's 042H. 04728.
04728H. Yes.
Mr. Chairman, I'll vote, I'll second the motion on the amendment.
Seconded by Representative Janvrin. Representative Muse, would you like to speak to your motion?
Yes, the amendment is to HB 89. This is the bill that would actually annul the convictions of Goody Cole and Willard Uphouse in New Hampshire. The amendment actually addresses some concerns that House Counsel had about some of the language that was used in the original bill. And so essentially the amendment dots the I's, crosses the T's, and helps us achieve our objective, which is to pass this bill without any legal issues down the road. Thank you.
Representative Janvrin, would you like to speak to your second?
Yes, Mr. Chairman, thank you. In 2020, I co-sponsored HB 1269, which was this same bill. I was joined by all of the representatives in the town of Hampton, and I currently represent the town of Hampton as well in this biennium. And the exoneration of Goody Cole is long overdue. So I support the amendment and the underlying bill.
Thank you. Any further discussion? Seeing none, I ask the clerk to call the roll.
Motion is for adoption of amendment. Vice Chair Rhodes?
Yes.
Representative Pratt?
No.
Representative Sytek? Representative Prue?
Yes.
Representative Janvrin?
Yes.
Representative Mannion?
Yes.
Representative Reed?
Yes.
Representative Stone?
Yes.
Representative Tenzar?
Yes.
Representative Harriet Gathright?
Yes.
Representative Muse?
Yes.
Representative Bolden?
Yes.
Representative Bradley?
Yes.
Representative Murphy?
Yes.
Representative Newman?
Yes.
The clerk votes yes. Representative Newell?
Yes.
Representative Nutting Wong?
Yes.
Representative Wheeler? Chairman Roy?
Chair votes yes.
Motion passes 19-1.
At this point, I would recognize Representative Muse for another motion.
Mr. Chair, I move HB 89 ought to pass with amendment.
I second it.
Moved and seconded. Discussion. Representative Muse, would you like to speak to your motion?
Yes, I think we've had this bill in front of us for the last 3 sessions, and as Representative Janvrin said, this is something that's important to the people of Hampton. These issues are important to a lot of people. Whenever we can't go back in history and correct an injustice, but what we can do is we can acknowledge that an injustice took place. We can't correct the injustice, but what we can do is we can correct the record. And that's really what we're attempting to do with this bill. This was an important bill. I had 2 other representatives in Hampton. One was the former chair of this committee. It was one of the last bills that he prime sponsored in the last session. Hopefully we can get this thing through, and I thank the chair for all of his efforts behind the scenes to make this happen. Thank you.
Thank you, Representative Jan. Would you like to speak to your motion? A second. I'm sorry, Representative Gathright. Would you like to speak to your second? Thank you. I would add that I was very careful with this, and I went to House Counsel, and we contemplated contacting the Supreme Court to make sure that we weren't violating any separation of powers issues. The statutes and the Constitution reserves certain rights to the courts and to the executive branch with as far as pardons and things of that nature. What this is doing is this is saying, as a body, we do not agree with what was done, and we feel that this should be corrected, at least historically, so that we can go on the record as saying that these were wrong, these things were wrong. It does not have a legal binding effect as if pardon were issued, but the voice of the legislature is going to speak on it. Any further comments or no? Okay, I'll ask the clerk to call the roll.
Motion is OTPA. Vice Chair Rhodes?
Yes.
Representative Pratt?
Yes.
Representative Sytek? Representative Prue?
Yes.
Representative Janvrin?
Yes.
Representative Mannion?
Yes.
Representative Reed?
Yes.
Representative Stone?
Yes.
Representative Tenzar?
Yes.
Representative Harriet Gathright? Representative Muse?
Yes.
Representative Bolton?
Yes.
Representative Bradley?
Yes.
Representative Murphy?
Yes.
Representative Newman?
Yes.
The clerk votes yes. Representative Newell?
Yes.
Representative Nutting Wong?
Yes.
Representative Wheeler?
Aye.
Chairman Roy?
Chair votes yes.
Motion passes 20-0.
Motion passes 20-0. It will go on consent.
Mr. Chairman, I would like to have this on regular calendar so we can speak to the bill on the House floor.
Okay, it will go on the regular calendar. Please make a note to the clerk. And I like to think that the Honorable Rennie Cushing is somewhere better right now, looking down on us, smiling. And with that, I will close the executive session on HB 89 and open the executive session on HB 498. And I recognize Representative Rhodes for a motion.
Thank you, Mr. Chair. I make a motion of ITL for House Bill 498.
Moved by Representative Rhodes, seconded by Representative Prue. The motion is inexpedient to legislate. Representative Rhodes, would you like to speak to your motion?
Thank you, Mr. Chair. We heard a lot of testimony on this particular bill, and all the fishermen that were here, you know, it was almost like if it was trying to make a wrong for them when they didn't feel that they had been wronged in any way. It was said how they actually appreciate the support that they get from Fish and Game. Additionally, the job the Fish and Game have, this would quite literally be putting the handcuffs on them. And considering that these are not emergencies, whenever they're doing their job, it would take hours, if not days, in order to get the search warrant. The site of Fish and Game alone does actually entice better behavior. And all the way around, I could go on and on because I have 3 pages of it. But at the end of the day, everybody that was here did not want this to pass.
For the record, except for the sponsor.
Except that's true story.
Representative Gathright, or no, except Representative Prue, would you like to speak to your motion?
Sure, I agree with the co-chair that, in the focus of their fish and game duties, getting a warrant would be, very cumbersome, and they do their job very well. When they switch into motor vehicle stops or anything else, they understand that all those regular rules, of search and seizure apply to them, and they would get the warrants. So I don't see any need to be changing anything. It's been working very well.
Thank you. I'll open discussion by saying I took the concerns of the prime sponsor very seriously. I looked at the statutes. If it were the case that Fish and Game could go on the roads and start enforcing motor vehicle violations and search vehicles and persons that had nothing to do with their fish and game activities without warrant, I would certainly be in favor of this. But I spoke to the House Counsel. I asked the Attorney General's office and the Fish and Game. All of them seemed to be of the same mind that that was not the case and could not provide a case, an actual case where this happened. If such a case exists in the future, I would be happy to entertain this bill again. But at this point, it does not seem necessary. Their waiver from having to get a search warrant is indeed the definition of exigent circumstances, because every time they are somewhere where they have to enforce this law, it is exigent because, well, frankly, no one's going to live in the woods and wait for them to get a search warrant or on the water. And I would open it up for any further comments or discussion. Anyone else? Representative Bolden.
I was impacted by the discussion during the public hearing about the concept that you waive certain rights when you apply for a license. And I appreciated hearing about that. And the aspect that it's communal property and that's the purpose of licensing and the regulation. That's all. Thanks.
Thank you. That makes perfect sense. Anyone else? Seeing none, I'll ask the clerk to call the roll. And the motion is inexpedient to legislate.
Vice Chair Rhodes,
Yes.
Representative Pratt,
Yes.
Representative Sitek, Representative Prue,
Yes.
Representative Janvrin,
No.
Representative Mannion,
Yes.
Representative Reed,
Yes.
Representative Stone,
Yes.
Representative Tenzar,
Yes.
Representative Harriet Gathright, Representative Muse,
Yes.
Representative Bolden,
Yes.
Representative Bradley,
Yes.
Representative Murphy,
Yes.
Representative Newman.
Yes.
The clerk votes yes. Representative Newell,
Yes.
Representative Nunning Wong,
Yes.
Representative Wheeler,
Aye.
Chairman Roy.
Chair votes yes.
Motion passes 19-1.
Representative Janvrin, do you object to consent?
I do not, and it will not be a minority report.
It is on consent. The motion ITL passes. I close the public hearing on House Bill 498. I open the public hearing on HB 545. Executive session. Thank you, Representative Sitek. And I recognize Representative Rhodes to make a motion.
Thank you, Mr. Chairman. I move ITL for House Bill 545.
Second. Representative Murphy seconds.
Yes.
Representative Rhodes, would you like to speak to your motion?
Yes, I would. Thank you, Mr. Chairman. When a sponsor comes and presents a bill, you take them at their word that what their intentions are and what what they look to achieve with the bill. And I have tried very hard to figure out exactly what the intention was with this particular bill, and I'm not really sure, to be honest with you. I do know that the people that work for the New Hampshire Coalition against Domestic Violence and Sexual Assault, that becomes their lives, and they lose sleep at night over some of the horror stories that they hear. They have worked diligently to continue the progress, and to go backwards with changing some of the protections that have been put into place is awful. And directly from a printout that we got, victims should never be responsible for the crimes committed against them, nor is it the victim's job to impose the bail conditions or determine the resolutions. That, or the restitution, I'm sorry, that says it all. Additionally, if you can start to pay off your victims so that they will drop their charges, we're really going backwards now. And it was also stated that, I believe that these people, they have tons of support and they have all these advocates. That's not true. It is not easy for the victims of any of these crimes. And a lot of times the person that is assigned to help them works for the court. They work for the DA's office to kind of be the liaison and a stopping point between that victim and the actual attorney to kind of, help field some of those calls, not necessarily to advocate for them. And it's also important to remember that the victim of these crimes, they are the state's witness. They don't just have protections. They are there to assist, but it's not necessarily against them. I could go on and on, but I don't think I need to. Gotcha.
Thank you, Representative. Representative Murphy, would you like to speak to your second?
Yes, I would. Thank you, Mr. Chair. I strongly support an ITL of this bill, although as it's presented, it's amending the Victims' Bill of Rights. It quite honestly does the opposite. Given that about half of all murder cases are domestic violence cases, and 80% of DV cases would be dismissed if HB 545 passes, it sets the stage for victim and witness intimidation. And given that the state has the duty to protect society at large from the defendant's behavior, I strongly support an ITL.
Discussion. Representative Newell.
I would just like to say, having worked with many people who have been victims of domestic violence, I think that unfortunately what this bill would do is that it would kind of exploit I'm trying to think of a better word than exploit the state of mind that people are put in when they're victims of domestic violence, and it would basically weaponize that against them, or has the potential to weaponize that against them. So yeah, I'm voting ITL.
Thank you. Further discussion? Seeing none, I'll ask the clerk to call the roll. The motion is inexpedient to legislate.
Vice Chair Rhodes?
Yes.
Representative Pratt?
Yes.
Representative Sytek? Representative Prue?
Yes.
Representative Janvran?
Absolutely.
Representative Mannion?
Yes.
Representative Reed?
Yes.
Representative Stone?
Yes.
Representative Tenzar?
Yes.
Representative Harriet Gathright? Representative Muse?
Yes.
Representative Bolden?
Yes.
Representative Bradley?
Yes.
Representative Murphy?
Yes.
Representative Newman?
Yes.
The clerk votes yes. Representative Newell?
Yes.
Representative Nunning Wong?
Yes.
Representative Wheeler?
Aye.
Chairman Roy?
Chair votes yes.
Motion passes 20-0.
The motion of inexpedient to legislate passes 20-0. Any objection, consent? Hearing none, it'll be on consent. I hereby close the executive session on HB 545. I hereby open the executive session on House Bill 581, and I recognize Representative Reed for a motion.
Thank you, Mr. Chair. I vote House Bill 581 ITL.
Is there a second?
Second.
Seconded by Representative Mannion. Representative Reed, would you like to speak to your motion?
Thank you. Yes. The Controlled Drug Act was instituted in 1970 with amendments made throughout the years. It has served as a good guide for medical professionals and law as well. And I feel that at this time, to repeal that even with a study committee is premature, and with our drug problem we're facing. I don't think there's any benefit to this. Maybe we can revisit it in a few years, when drug laws, regarding marijuana change. We can revisit it then, but right now, I, move to ITL this bill. Thank you.
Representative Mannion, would you like to speak to your second?
No, thanks.
I would, I'll start the discussion. I think that folks that support marijuana legalization need to be very careful of these bills. Right now, the federal government is kind of turning a blind eye to some of the states that are selling and allowing marijuana for even medical use. Currently, it is still illegal federally, and at any point, that could change, and the federal government could decide to come in and shut everything down and arrest everyone involved in the production, distribution, selling medical marijuana cards or not. Until such time as the federal government changes these laws, continuing to flout them by trying to legalize all kinds of different drugs at the same time is going to get the attention you don't want, and it's going to bring the enforcement hammer down. We need to move our federal delegates to change the laws at that level before we continue to pass legalization bills at the state level that are just going to bring negative attention to the populace of the state. And some people who rely on medical marijuana for their medical conditions will suffer. Further discussion. Representative Newell.
Just to say quickly, agree. Also, I am completely for decriminalization and legalization. I do feel like it needs to be done in a specific way. It needs to be done in a responsible way, starting with what you said as well. And you know, there needs to be supports, there needs to be regulation around it. I just feel very strongly about it not being illegal, but it being legal in the right way so that people are protected and using responsibly and the least harm.
Representative Wheeler.
With respect to Representative Reed, the chairman, and Representative Newell, I do disagree with the ITL motion. Seeing as though the Controlled Drug Act was passed in 1971, and to paraphrase what the assistant to the president for domestic affairs said when asked about the Controlled Drug Act, it was, we couldn't illegalize being against the war or being black, so we had to illegalize cannabis for the hippies and heroin for the blacks and criminalize them as much as possible. And seeing as though that was the intent for the Controlled Drug Act when it was passed, they didn't think too much into it. There wasn't the necessary regulations to make sure it was safe and a cogent policy. They just implemented it to stop discussion on the war in Vietnam and organizing that was going on in the black communities. I think repealing a law which was so egregiously passed would be beneficial for the New Hampshire state government, and I think the harms that you illustrate would be worthwhile, because sometimes there has to be some negative conversations to get to where you want to go in terms of repealing something so egregious. So I'll be voting against the ITL motion.
Thank you. And I respect your opinion, and who knows which one of us is right, but until we get the feds to fix it, we're really just spinning our wheels. Any further discussion? Seeing none, I'll ask the clerk to call the roll. Motion is inexpedient to legislate.
Vice Chair Rhodes?
Yes.
Representative Pratt?
Yes.
Representative Sytek? Representative Prue?
Yes.
Representative Janvrin?
Yes.
Representative Mannion?
Yes.
Representative Reed?
Yes.
Representative Stone?
Yes.
Representative Tenzar?
Yes.
Representative Harry Gathright?
Yes.
Representative Muse?
Yes.
Representative Bolden?
Yes.
Representative Bradley?
Yes.
Representative Murphy?
Yes.
Representative Newman?
No.
The clerk votes no. Representative Newell?
Yes.
Representative Nutting Wong?
Yes.
Representative Wheeler? Chairman Roy?
Chair votes yes.
Motion passes 17-3.
Representative Wheeler, will you be doing the report on this? You
You'll
seem
give
to
me
be.
on all the drug bills, I guess. No, I'm willing to do the minority report on this, absolutely.
You do want to, you don't want it on consent, correct? Okay, thank you. With that, I will close the executive session on House Bill 581, the motion of inexpedient to legislate passed. I will open the executive session on House Bill 191, and I'll recognize Representative Stone to make a motion.
Thank you, Mr. Chair. I'd like to make a motion to ITL Bill 191. This bill, if passed,
Thank you. Would you like to speak to your motion?
yes, sir, I would. This bill, if passed, would add an additional burden on state agencies to include state police and judiciary. There are currently other viable options for legitimate firearms disposal that comply with both state and federal law.
Representative Prue, would you like to speak to your second?
What he said.
Thank you. I really, this one was a little confusing. I think they can be destroyed now if they want to. They seem to have a process in place. The state police didn't take a side on it, but they did point out that it could be costly. So, any other discussion? Could the clerk please call the roll when she gets a second?
Motion is ITL. Vice Chair Rhodes?
Yes.
Representative Pratt?
Yes.
Representative Sitek? Representative Prue?
Yes.
Representative Janfrin?
Yes.
Representative Mannion?
Yes.
Representative Reed?
Yes.
Representative Stone?
Yes.
Representative Tenzar?
Yes.
Representative Harriet Gathright? Representative Muse?
No.
Representative Bolden?
Yes.
Representative Bradley?
Yes.
Representative Murphy?
No.
Representative Newman?
No.
The clerk votes yes. Representative Newell?
No.
Representative Nutting Wong?
Yes.
Representative Wheeler?
Aye.
Chairman Roy?
Chair votes yes.
Motion passes 16-4.
Motion of inexpedient to legislate passes 16-4. I hereby close the executive session on House Bill 191. Who's doing the report on that one? Representative Stone is doing the, what about the no report? Representative Muse? Monday, some point. Thank you. I'm opening the executive session on House Bill 305, and I recognize Representative Rhodes to make a motion.
Thank you, Mr. Chairman. I move ITL for House Bill 191.
And I will second that.
Seconded by Prue. Would you,
I'm sorry, my bad. 305. Wrong one.
We knew what you meant.
I
And
move
you-
ITL for House Bill 305.
and your second was to 305, correct?
That's-
Okay. Would you like to speak to your second? Your motion.
I would gladly yield if somebody else can explain exactly what was happening here.
Okay. Representative Prue, you want to take a crack at it?
I don't think this is the right time for this bill. It kind of muddies the water. Working with the feds and when they can and when they can't, and I just don't see a need at the moment. But I'm good.
Representative Tenzar, did you want to talk about this?
I'm in agreement with this. I just think that there was some confusion amongst the committee as to Representative Mannion's testimony. I would request that we have a subcommittee on this to get more information out of it.
I'm inclined to agree. I don't think we really understood what the heck just happened. So I would like to, I'm going to go ahead and take that advice, and
I'll withdraw my second.
if Representative would be
I'll
kind enough.
I'll withdraw it.
Thank you.
I don't.
Having said that, okay, the motions have been withdrawn. It is open for further motions. At this point, I'm going to appoint a subcommittee, and we are going to take a quick look at that. I'd like it a 1-week turnaround if I could. Representative Tenzar, you're the chair. Anyone else want to get on this? Representative Stone?
No, you're not.
You want to be on it? Anyone? Wow. Representative Mannion, I'd like some folks from the other side. We've all blended so close now that I can't tell the difference. Representative Wheeler, thank you for volunteering for
I'll
that.
help out
subcommittee.
my seatmate here. That's fine.
You're like the drugs and gun.
And Representative Reed, would you mind, Representative Reed? You're laughing, but would you mind, Representative Reed, rounding that up, please? Yeah, it's not funny anymore, is it? Representative Reed. Okay, with that, we will take this back up next week after the subcommittee gets us some more information so we can understand it. I hereby recess the public hearing. Executive session, yeah. Okay. I am recessing the public hearing on House Bill 305, and that concludes our business. Representative Sytek would like to be recognized for a remark before we all leave.
Can't hear.
We can't hear you.
Can't hear.
I listened to Representative Wheeler's statements about the origin of the Controlled Drug Act and its motivation. I hope he's not right.
I'd be happy to show you the quote afterwards, Mr. Saite.
Oh, we're sure you're right. It's just sad that that's how it came about.
It is very sad, absolutely. But we have an opportunity to reasonably change it, hopefully.
Mm. Oh, thanks.